In this lecture, we're going to continue our focus on the procedural aspects of the law, meaning how is it that the parties can enforce the law when some right or obligation has been breached. And we're going to start by looking at litigation. Litigation is a form of dispute resolution in which claims are resolved inside the court system. So in today's lecture, we know that disputes often arise in business, and often these disputes can be resolved through informal processes, things like negotiation or mediation, and we'll be touching more on those in the next lecture. However, if informal negotiations don't succeed, the parties will then seek another form of dispute resolution, and that's likely to be litigation. Litigation involves filing a lawsuit in court and allowing the judicial system to insist in the resolution of the dispute. So in this lecture, we're going to look at the stages of civil litigation and discuss how it is that disputes are actually resolved. I'm sure a lot of you are going to be familiar with bits and pieces of this because of media, because of watching movies or seeing it on TV, but now we're going to see how this actually works in real life. Let's talk about civil litigation as a means of resolving disputes. Now, when I was practicing prior to starting my academic career, this is what I did mostly, civil litigation. And so I've seen a lot of these cases being resolved, and I can recognize the benefits and the drawbacks of our current litigation system. Now, civil litigation is the process of resolving disputes between private parties using the court system. So this is the means of resolving a dispute between a business and a business, or a business and an individual, or two individuals. Civil litigation involves allegations of non-criminal wrongdoing. I mean, those wrongs that are not crimes. We call those wrongs civil wrongful acts. Things like negligence and other forms of tort and breach of contract. Wrongdoing, but non-criminal in nature. Now, most civil litigants are seeking monetary relief. Money damages is primarily what people are interested in when they file a lawsuit in court. Now, some civil litigants may seek injunctive relief. In our introduction to the legal fundamentals, we talked about the difference between monetary damages and equitable damages. Injunctive relief is a form of equitable remedy. Let's talk about the basis for civil litigation. One party, and that party is going to be referred to as the plaintiff, is usually seeking compensation or some other remedy from another party, who is referred to as the defendant. So whenever you hear me mention plaintiff in here, we're talking about the party who is seeking relief, the party who has filed the lawsuit, the party who is complaining. The other party, the defendant, is the party against whom relief is sought, the person that has to defend oneself. The plaintiff is the party seeking relief. The defendant is the party against whom relief is sought. Make sure you're aware of these for your exam. Be able to spot who is the plaintiff and who is the defendant. Now, there are numerous different types of civil cases, and your book includes a long laundry list of these. Things like personal injury claims, or antitrust litigation, civil rights actions, product liability suits, employment disputes, corporate matters, real estate. All of these are subject to resolution in a court of law. Matters that arise out of these types of civil cases are going to be decided by the court system. Now, there are 3 basic phases to civil litigation, and we're going to talk about each of these in turn, but let me introduce the phases of litigation. The first is what we call the pretrial phase, before trial phase, and this is where most of the work is done. Most work is done in the pretrial stage. This will occupy the majority of time for any case, even a case that is appealed all the way to the state or federal Supreme Court. Most of the work is being done in the pretrial stage. The second stage is the trial. This is where the dispute is actually resolved, and a jury or a judge will decide the facts of the dispute. And if either party is seeking relief, the party can then seek post-trial relief through the appellate court system. So those are our 3 phases: pretrial, trial, and post-trial. Pretrial procedures will consume most time and resources. Most disputes will be resolved during the pretrial phase, oftentimes through a negotiated resolution, a settlement, sometimes reached because of a mediation that was held. But in any event, most disputes are going to be resolved during this phase. Only a very few disputes reach a trial setting. One of the most important motions that we'll be talking about in here is what we call a motion for summary judgment. And a motion for summary judgment is going to ask the court to end the case prior to trial. And so one of the reasons why so few disputes reach a trial setting, that even in those cases that aren't voluntarily settled, a court will often grant a motion for summary judgment. And we'll talk a bit more about that. Even fewer disputes are ever appealed. Oftentimes, even if there is a party who is not happy with the outcome of the trial, that party may seek to resolve the matter after the trial, but before filing an appeal. Let's talk about the pleading stage, the first stage in the trial. Now, the plaintiff initiates litigation. The plaintiff, the party who's seeking relief, initiates litigation by filing a document called a complaint. Now, in state court, this initial document is generally called a petition, but they are essentially the same thing. And what the complaint does is it sets out certain elements, things like jurisdiction. So in the complaint or the petition, the plaintiff explains why this particular court has jurisdiction. And you will remember that jurisdiction includes 2 elements: subject matter jurisdiction and personal jurisdiction. There will also be a short narrative, sometimes a bit longer than that, but it is a narrative alleging certain facts, containing the factual allegations, meaning the plaintiff is stating that this is their version of the facts, and these are the facts that the plaintiff is asking the court, whether it's a jury or a judge, to find. A complaint will often include a cause of action. That means the legal basis for bringing the complaint. So the complaint may specifically state this is a breach of contract claim, or this is a negligence claim. And then finally, there will be a demand for relief. The plaintiff will tell the court what it is seeking by filing the lawsuit. And so every complaint, no matter whether it's a simple matter or whether it's a very complicated matter, whether it's a $500 dispute or a $1 million dispute, every complaint contains these same elements. Now, the defendant responds by filing what's called an answer, and it is called an answer in both state and federal court. And in this answer, the defendant, the party against whom relief is sought, responds to the allegation of the plaintiff's complaint or the petition. Now, in state court, it is often permitted to file what's called a general denial, which is to say the defendant denies everything that the plaintiff is claiming. But in federal court, the defendant must respond to each allegation. Each of the factual allegations in the plaintiff's lawsuit must be responded to by the defendant. So it is difficult to file an answer in federal court, much simpler to file that answer in state court. Now, in federal court, for each and every allegation in the petition, the defendant may first admit the factual allegation, admit it, yes, this is true. Oftentimes not done other than for matters such as this is our proper name or jurisdiction is proper. The defendant can also deny the fact. They can deny the fact, saying this is denied. The factual allegation is false. Or they can claim insufficient knowledge as to whether the allegations are true or not. And in most lawsuits, this is probably the answer that should be filed, because oftentimes in the early stages of the lawsuit, the defendant has little idea of the truth or falsity of the allegations made by the plaintiff. In the answer, the defendant can also file its own lawsuit, and it does so by filing either a counterclaim, a cross-claim, or a third-party complaint. A counterclaim is a claim for relief by the defendant against the plaintiff, which is to say, no, I didn't breach the contract, you breached the contract. You have caused me injury. And so at that point, the defendant remains the defendant, but also becomes a counter plaintiff, meaning all disputes arising out of any transaction between these parties must be heard in the same lawsuit. So a defendant who has a claim against the plaintiff must bring that claim in the original lawsuit that the plaintiff filed. And the way they do that is by filing a counterclaim. Now, a cross-claim is a claim brought by a plaintiff against a co-plaintiff or by a defendant against a co-defendant. Oftentimes, these cross-claims are filed when the plaintiff sues two parties, and one of those parties believes that it was the other defendant who caused the harm. And so that defendant will file a cross-claim against the other defendant under the theory that if I am found liable, then I need to turn to the actual person who committed the wrong. So that's a cross-claim. And then finally, there is a third-party complaint. It is a claim by a defendant who is now a third-party plaintiff against a non-party who becomes a third-party defendant. I'll tell you about a case I had involving a accident that occurred at a Kmart in San Antonio. The plaintiff slipped and fell in a mysterious substance at the Kmart. And so Kmart did not know what the substance was, and in fact it was cleaned up prior to ever learning what the substance was. And so the plaintiff sued Kmart. Kmart says if there was a substance on the floor, it wasn't ours. And so Kmart turns around and sues my client, who is the cleaning contractor, who comes in to clean the floors every night, under the theory that if there was something slippery on the floor, it must have been left there by the cleaning contractor. And so my client is a third-party defendant. And what often happens in that case is that the original plaintiff now brings a claim against the third-party defendant, and so I become both a third-party defendant and a co. I know it's a bit complicated, but this is how the parties are aligned prior to the trial. Now, in the pretrial stage, once the pleadings are set, once the plaintiff has filed their complaint and the defendant has filed an answer, the parties go to the next stage, which is called the discovery phase. And in the discovery phase, the parties are attempting to narrow the issues. They are trying to determine what issues are actually disputed and what issues are actually agreed to. So this discovery stage, the trial court's function is to determine the facts. And during this stage, the parties are going to try to determine exactly which facts are in dispute. So the discovery stage is really about limiting the lawsuit. By the time trial arrives, theoretically, the only issues that are going to be heard are those about which there is a genuine dispute. Now, during the discovery stage, the parties will oftentimes go back and amend their pleadings as more facts are revealed. As the plaintiff learns more information or the defendant learns more information, they will often go back to amend their pleadings. And so we'll get an amended petition or amended complaint and an amended answer. And this is all in response to the things that have been learned during the discovery phase. Now, discovery is that process of gathering information to prepare for trial. Discovery in our system, in the American judicial system, is often very extensive, and that means that it's also very expensive, that it is costly. Plaintiffs routinely will ask for virtually every document that may be relevant to the case, and defendants will oftentimes be in the position of producing literally millions of documents in response to a plaintiff's request. So discovery is this legal process that lets each side of a suit ask the other side for information that is related to the case, that is relevant to the case. During discovery, each party must show to the other side any evidence that they plan to use as trial. So if you are going to use some evidence, whether that is testimony or whether that is a document, it must have been produced during discovery, or else you will not be able to introduce it at trial. Now, certain disclosures, what we call initial disclosures, are automatically required in every case. Now, this is a document that's pretty recent overall, that up until the early 2000s, discovery was pretty straightforward. It was often very expensive and time-consuming, but it was generally meant to obtain information from the other side. But what the courts discovered was that discovery was being abused. And so they created this initial stage of discovery in which each party is responsible for making certain disclosures, telling the other party what their name is, telling the other party what state they are a resident of, outlining your basic defenses. All of these are automatically required without the need for a discovery request from the other side. So this came out of federal court. It's very similar to what courts in Europe do, what courts in England do, which is to say each side produces the evidence that they think is important to resolution of the trial. The United States, however, takes a very different view of discovery. Discovery in the United States is incredibly broad. It can include asking for documents or tangible things or information about people who have knowledge of relevant matters. And generally, a party can ask for any information that is not privileged, which is usually the attorney-client privilege, and is relevant to the lawsuit, or information that is calculated to lead to relevant evidence. So the scope of discovery in the United States is broad. Now, evidence is relevant if it has a tendency to produce a fact, to prove a fact, and that fact is important in the lawsuit. Let's talk about the primary means of discovery, starting with depositions. Now, in a deposition, a witness is asked questions by the opposing counsel. That witness is sworn in, and when they give their testimony, it is recorded by a court reporter, an independent third party. And everything that the witness testifies to is going to be subject to the same oath as if the witness was in court. And in fact, if a witness is not available for trial, or a plaintiff doesn't want to make the witness available for trial, the deposition itself can substitute for testimony. So everything said in a deposition is just as if it was said in front of a jury. Interrogatories are written questions directed to the opposing party. Now, I mentioned that there was a lot of discovery abuse back in the 1990s, oftentimes wherein parties would be asked to respond to literally hundreds of these interrogatories, these written questions. Now, during a wave of change in the 2000s, those interrogatories were limited, and now generally the plaintiff can ask about 30 questions, including subparts. But these are written questions to the opposing party, and once again, the opposing party must answer those questions under oath. They must be testifying to the truth. It's sort of a written form of testimony. Now, there's also document request, and there have been really no limitations on document request. You can request millions of documents. You can request all of the emails that may have been exchanged. You can request the text messages that may have been exchanged regarding a suit. It is, document requests are extremely broad, and this is one of the reasons why litigation is so expensive. I was involved in a large piece of litigation involving a patent infringement, and our side, who owned a patent and was suing another party for infringement, had to produce literally millions of documents, and we had to review those documents before we produced them. And so we had a team of about 6 or 7 lawyers, and all they did for 6 months was to look at these documents to decide which ones should be produced to the other side and which should not. So document requests are part of the expense found in litigation. Now, during the pretrial stage, following discovery, there are often a number of motions that may be filed, and either party can file motions during this pretrial phase. One of the motions that we see regularly is a motion to compel discovery. If you, as a plaintiff or as a defendant, believe that the other party has not been open about their answers to discovery, you may then turn to the court and ask the court to force the other side to give up the appropriate documents or to produce the witness for deposition or any of those. And so courts do not like motions to compel discovery. However, they are still filed all the time. A motion to dismiss is made oftentimes by a defendant who believes that there is no claim against it, that there has been no basis for a lawsuit. The cause of action has certain elements and the plaintiff has not met those requirements. So a motion to dismiss is often brought early on during the pretrial phase, especially after discovery is finished, because you are arguing that there is no lawsuit, there is nothing to try. Now the third motion, the motion for summary judgment, this is probably the most important motion that you will encounter in business, whether you are a plaintiff or a defendant. Now the motion for summary judgment is usually filed by the defendant. The reason why is the plaintiff usually wants to reach the jury. The plaintiff believes that they can influence the jury to see things their way. A defendant doesn't want to go to a jury. A defendant doesn't want to go to trial. And so they file what's called a motion for summary judgment. And what this motion says is there are no triable facts here. Everything has been decided. The only issue is legal issues, which are going to be decided by the judge anyway. And so one files a motion for summary judgment to say there are no triable issues of fact. There are no facts in dispute in this case. There is nothing to try. Motions for summary judgment are granted fairly frequently, and what they do is it's just as if the case went all the way through a trial and then ended in a judgment for the defendant. So the summary judgment happens prior to the trial, and it is something that every defendant will want to file and hopefully get granted so as to avoid the cost of a trial. Let's talk about the trial stage. A trial may be tried to a judge. Sometimes the parties, for whatever reason, will choose not to use a jury. In one of the last cases I was involved with prior to coming to OSU, it was a case in New Orleans. And in this case, my client was a contractor who had done work following the hurricane in New Orleans and was very concerned that a jury would frown upon someone who came in from out of state to do work and take advantage of the people of New Orleans. The defendant on the other side was actually an insurance company, and insurance companies were also not popular with the people of New Orleans. And so myself and the opposing counsel decided that this is a case that should be tried to the judge. And in this case, we had a very good judge, and the judge we could trust to find the facts accordingly. This is generally referred to as a bench trial. A bench trial is a trial to the judge, a trial without a jury. Now, plaintiffs will generally seek a jury trial, but the parties can sometimes agree to a bench trial. Juries. A trial may involve use of a jury. Now, how do we get a jury? Some of you may have been called up for jury duty. Some of you may have served on a jury. It's pretty rare, but you may have been the one. I would love to serve on a jury, but I've never have. I've been called a couple of times, but they've never reached me. And one of the reasons why people are excluded from juries has to do with the jury selection process. Now, we call this process, depending on where you live, in Texas we call it voir dire. In Louisiana, where I began practicing, we called it voir dire. But in essence, this is the stage in which we are able to select a jury. This is the only time in the process in which the counsel, the plaintiff or the defendant's attorneys, can speak directly to the jury. And so the jury is brought into a room with about 40 people in the jury panel, and then the plaintiff and the defendant will take turns asking the jury questions. You can't ask specifically about your particular case, but you can introduce the themes of your case. You can introduce what the case is about. So if you have a case involving a car wreck, for instance, you as a defendant may not want anybody on the trial who's been in a car wreck or who has been a plaintiff in a car wreck case. And so we ask about that, and we're able to exclude people. Now, there's two kinds of exclusions that can be made during the jury selection process. The first would be those exclusions for cause. And if a person says, for instance, I cannot be fair, then they can be excluded for cause. If the person on the jury knows one of the parties involved or is friends with the judge or the counsel, they can be excluded for cause. Now, each side is generally given a number of jury strikes, oftentimes 6, for non-cause. And so using that, we can take off those people on the jury panel that we feel are most predisposed to our opponent. These are oftentimes controversial. We can pretty much exclude anyone we want with one notable exception, which is race or ethnicity. You cannot remove a person from the jury based on race or ethnicity. But the jury process then ends after the appropriate members have been struck, and we are left with a jury, generally 12 people. In some county courts, it's 6 people, but generally 12. So a jury selection process is not really jury selection. It's really jury deselection. And so you often wind up on the jury with people who have very little knowledge of the type of dispute at hand. Once the jury has been chosen, then we start the trial. And the trial starts with opening statements. Now, again, at this point, the plaintiff and the defendant, their attorneys, will take turns outlining the case for the jury. This is what the case is about. This is what we intend to prove, or these are the things that will explain why we are not liable. In the opening statement phase, each side takes turns explaining their view of the case. The trial then proceeds in stages, starting with evidence, presentation of evidence. Oftentimes, this takes the form of direct and cross-examination. I'm certain you have seen this on TV or in the movies. Now, in real life, it is similar in some respects, but it's also not as similar in others. For instance, in very few court systems are you able to actually stand up and roam around while you question the witness. In Texas, you have to be seated at a table when you examine a witness. In federal court, you go and you stand at a podium and you take turns standing at the podium and asking the witness questions. So it's not nearly as exciting as it is on TV. But at that point in the trial, you are producing evidence, either to support your side or to explain why you are not liable. Following the presentation of evidence, each side will rest, and at that point, the counsel will make their closing arguments. First the plaintiff, then the defendant, and then another chance for the plaintiff. And this will be the last opportunity to explain to the jury, to appeal to the jury to find on your side. Generally, juries have made up their mind about this point, But what you should do is you want to reinforce the statements that you've made, whether you are the plaintiff or the defendant. This is actually the aspect of trials that I enjoyed the most, because it was a chance to get up and really preach to the jury, to explain your side, and to explain why they should rule as you have asked them to rule. At that point, the jury will receive instructions from the judge. The judge provides instructions to the jury, and then the jury goes out to make its final verdict. The verdict will set out damages, and those damages could be what we call special damages. Special damages are those damages that are easily calculated, things like property damage or medical bills. There is also the potential for general damages. Those are the open damages, things like pain and suffering or loss of consortium, or even punitive damages, damages that are meant to punish the defendant for its alleged failures. Once the verdict has been reached, the trial court remains in control of the litigation for a short additional period. Now, during this period, either party can file what are called post-trial motions, starting with a motion for a new trial. Either party can ask for a new trial. There was something that went on, something that was wrong, some evidence that was admitted, or some wrongdoing by the jury which would justify a new trial. The second type of motion, this is generally filed by the defendant, is a motion for judgment notwithstanding the verdict. It's often abbreviated JNOV, JNOV standing for the Latin phrase judgment non obstante verdicto, which is to say, give us judgment notwithstanding what the jury said. The jury got it wrong. Very hard to win a JNOV, but it is possible. Once the matter has been decided, either party can appeal to a court of appeals. Now, a court of appeals is going to have its own rules and procedures. We're not going to address those in here, but you should know that they exist. An appeal is a legal argument presented to a panel of appellate judges on issues of law. So generally, appellate lawyers are not the people who tried the case. Instead, you bring in specialists to handle the appeal. Appellate law is a very different form of advocacy than is trial law. And what the appellate court will do, remember, they can only decide matters of law, so they will look for any errors in legality made during the pretrial or the trial proceedings. And as I said, that's oftentimes the judge admitted evidence that they should not have, or the judge failed to admit evidence that they should have. After reviewing the proceedings, the appellate court then releases an opinion, which is the appellate court's decision. After hearing arguments, in their decision, an appellate court can do one of three things. First of all, it can affirm the judgment of the lower court, which is to say the lower court got it right. Case is affirmed. The judgment is affirmed. They can also reverse the judgment of the lower court in part or in its entirety. They could argue that, they could explain that the lower court got it wrong for any number of reasons. Much more likely is that the court will remand the case to the trial court, which is to say, trial court, this is now back in your ballpark. We have identified errors in the decisions you made as a judge. You need to correct those errors and give these parties a chance at another trial. So in conclusion, what did we learn today? First of all, civil litigation is the process of resolving disputes between private parties in the court system. Civil litigation has three basic phases: pre-trial, trial, and post-trial. And finally, we know that litigation is expensive and time-consuming. That's it for this lecture. Thanks a lot for listening. If you have any questions, please reach out. Otherwise, I will see you in the next lecture.